Good afternoon, friends. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, we're going to discuss recent news regarding expedited removal. And if you have not subscribed to my channel yet, please do so and hit that notification bell so you will stay updated regarding the most recent immigration news. I also provide some tips and my thoughts as to how this or that change may affect various cases in various immigration situations. So let's talk about this new or renewed expansion of expedited removal. As you may be aware, the first proposal to expand the expedited removal came from the Trump administration back in July of 2019, and it was met with a lawsuit, and for a while ICE did not use that announced expanded expedited removal powers against people who are in the United States already, not next to the border. But on September 30th, a federal court stated that ICE can go ahead with the expedited removal. So what is expedited removal? Who can fall into that category and can be now a subject of that expedited removal? Well, it's been for a very long time that expedited removal was used usually for somebody who is seeking admission at the border, right, trying to get into the United States, or someone who is caught next to the border, within 100 miles of the United States border, and has not been in the United States for longer than 2 weeks. So basically, expedited removal has been used as a tool to send someone back fast if they haven't been in the United States for a long time, and if they're not requesting asylum. It's very important to know that. Now the proposal to expand this expedited removal tool and include not only people who are apprehended at the border or trying to come to the United States, but also those people who are physically inside in the United States, okay, not anywhere near the border, and who cannot prove that they have been residing in the United States continuously for 2 years. So basically anyone who has been in the United States for less than 2 years and now does not have a legal status can be subject to expedited removal. There is a big difference between regular removal proceedings and expedited removal proceedings. In the regular removal proceedings, a person can see a judge, immigration judge. A person may assert, may put forward, may use various reliefs from removal or deportation. But in expedited removal, sufficiently there is only one relief available. It's asylum, withholding of removal, and relief convention against torture. There will be slight variations into qualifications for the three types of practically the same relief. There are legal differences, but the main component of all of them is fear, is that the person is afraid of going back to their home country, and that is why he or she is asking the United States government to let them stay in the United States. Another big difference between regular removal proceedings and expedited removal proceedings is that very often the person who is subject to expedited removal proceedings is detained, especially until he or she passes credible fear interview. And now, with the new changes, that person can be detained until the judge actually makes a determination on the application. So it can be a very long time. Of course, we have to also take into consideration new asylum law changes, right? The fact that now the person is not going to qualify for an employment authorization if they're filing for asylum past 1 year deadline, unless they're excused, and this determination of excuse is made by an asylum officer or judge, the fact that frivolous or meritless asylum claims are going to be disposed right away by asylum officers. So basically, the expansion of expedited removal means swift deportation for many, many people who are in the United States. How one can protect themselves from this expedited removal, if it's going to happen? Well, of course, the main protection is for a person to prove that he or she has been residing in the United States for more than 2 years. So you have to have those documents ready if this is your case. Another potential protection, as I stated, is an application for asylum, withholding, and relief under the Convention Against Torture. Okay. Of course, if you don't have other applications going on, right? If you have a pending application, you absolutely have to have a receipt and proof that that's what's happening in your situation. So when exactly the question is going to start? When exactly, if you encounter an ICE officer, you should be worrying about this expedited removal procedure? Apparently, starting next week, because right now officers are in training. They're receiving extra training as to how to implement that expedited removal. I understand the training is going to include, training as to how to make sure, determine if the person falls under the new guidelines for expedited removal or not. And then the officers are going to start implementing it. Does it mean additional ICE raids? Perhaps. Well, they have been going on, they haven't stopped. So we know that. Perhaps. So you need to be ready. And in general, if you know that you have an issue with your immigration status, it would be prudent, it would be wise to prepare for something like an encounter with a law enforcement, especially nowadays when everything can happen very quickly. I actually have a nice blog about the expedited removal. I wrote it back in 2019 when it first was announced, and I'm going to post it in comments or in the description to this video. So this is the picture for the expedited removal. I hope that you will not have to deal with that, but if you will, or you're worried that you might have to, please share this video, read the blog. If you have some questions, contact us. We will do our best to help you. And thank you very much for watching. Subscribe, share, and I hope to see you soon.